us online today. The Senate Judiciary Committee meeting is called to order. We are starting a little bit late today due to the fact that in the legislature we are approaching what's called the turnaround deadline, and today is the last day for committees to meet to pass out of committee bills either from the House of origin, so Senate bills in the Senate and House bills in the House, and then they must pass across the chamber floor or not by next week, March 5th. So it's kind of the general rule for bills unless they run through exempt committees, and we are a non-exempt committee. But in any event, so we are going to then turn to working some bills today. I want to thank the committee and those who were watching online last night. We had 2 meetings yesterday of the committee instead of 1, and we worked until almost 7 p.m. last night. I was remiss in not thanking our committee staff for the hard work yesterday, and our IT staff as well for making everything run smoothly. I always appreciate that. So committee, we do have a bill that was referred to committee this morning or yesterday, and it does concern the speedy trial, which we had been talking about. We've heard a couple days of testimony on Senate Bill 57, which is the statutory speedy trial right, and we now have the House version of it. The House version was passed 107 to 17, and it's HB 2078. We're not going to hear that today, and we're going to then work on the statutory speedy trial issue after turnaround. So keep that in mind. As we proceed forward, we will need to first hear House Bill 2078 and then work that bill. That gives us time today to work on a few things, and one of those, we have heard both the Senate bill and the House bill on it, and that would be Senate Bill 3 and House Bill 2026 regarding diversion, actually that is diversion for those related to drug offenses. And I will let the reviser please do a better job of explaining the bill than I have. We heard it some time ago. Again, we've heard both the Senate and the House version, which are the same, but we've had a lot of testimony about it. So we will now turn to working House Bill 2026. If we could have a bill brief from the reviser, Mr. Thompson.
Thank you, Madam Chair. Good morning, Committee. Jason Thompson with the Revisor's Office. House Bill 2026 is the bill that creates a certified drug abuse treatment program for people on diversion and allows county and district attorneys to enter into agreements with court services or community corrections for supervision of those people placed on diversion. Not to get too into the detail on the bill brief, but new section 1 is the provision that creates that drug treatment program for people who enter into a diversion agreement on and after July 1st of this year. It would be limited to those folks given diversion for an offense in grid blocks 5C through 5I, so we're down on the lower end of the grid in the possession range only, and with no A or B criminal history. This would be similar to what's in the Senate Bill 123 drug treatment program for folks that are convicted. So that's the comparable thing that's created here for people on diversion. And then the second section of the bill allows county and district attorneys to enter into memorandum of understanding with a chief judge to get court services supervision for their divertees, or to work with community correctional services to get supervision for their divertees. And I think that probably sums it up for now.
Thank you, Mr. Thompson. Committee, questions for the reviser? Senator Haley.
Madam Chair. Mr. Thompson, is there a bed space impact with this, I don't have my file. I mean, how will this affect, or will it affect our bed space? Do you know?
Thank you, Senator Haley. There was some, if I recall, confusion about the report that we had from the Sentencing Commission and whether it would increase the number of beds or decrease the number of beds. But here's a copy of it, Senator, if that would help. And because you would think that if we're having people enter into diversion agreements, it would help lower the number of prison bed spaces that are occupied through this program. But Mr. Revisor, if you can respond.
Thank you, Madam Chair. It's Jason Thompson again with the Revisor. I have the same, not fiscal note, prison bed space impact assessment from January 13th of 2021, I believe was the one we have from Executive Director Schultz of the Sentencing Commission. It just says it may result in additional prison admissions, but they cannot determine exactly. The main impact on the commission is that it would increase participation in the Senate Bill 123 drug treatment program by potentially 25, 50, or 75 persons. And the impact on that, they estimated some of the fiscal impact there in the prison bed space impact from potentially around $88,000 on the low end to $265,000 on the high end.
Thank you, Madam Chair and Mr. Thompson. So my concern, because I don't quite get the dichotomy of the increase to participation in Senate Bill 123 and how it will result in us undertaking to need additional beds. Just a concern that I have that has permeated certainly my service on the Sentencing Commission as well as on this committee is we are usually running, just for everyone's awareness, at 100% of capacity for our bed space in our prisons, and I have been consistently concerned about passing subsequent legislation that somehow adds to the burden that we already have, and I just don't quite. Frankly, I appreciate the explanation, Mr. Thompson, and your sharing, Madam Chair, with me the statement from early January from the Sentencing Commission, but I just don't understand how greater participation in these programs will lead to the bed space increase that this imagines. But thank you for the insight.
Thank you, Senator. Committee, any other questions for the Revisor? I have one. Go ahead, Mr. Thompson.
Could I just add one more thing? This is Jason Thompson again with the Revisor. Now that Senator Haley sort of clarified put a finer point on the issue here. If I remember Mr. Schultz's testimony correctly, so these folks are getting diversion now, and this would make them eligible for treatment. So it increases the cost of that treatment program, right? They'd be eligible for Senate Bill 123, and they aren't currently. So that's where the cost comes in. I think what he was saying about the prison beds is it may increase them because if they fail on the program, they would have their diversion revoked, and that might end up sending them to prison, versus now where if they fail in their diversion, they may not fail in their diversion because they don't have a treatment program, right? So they do their diversion, they don't do treatment, they're over with diversion, and they're never revoked and sent to prison. So they're unable to quantify, but they just put out there the possibility that it may lead to some folks going to prison just because we're keeping them in the program and maybe supervising them more closely than we were before. And I don't want to speak too much for him, but I think that's how I understood what he was explaining.
Sure. Senators, any other questions for the Revisor? I have one question. Could you tell us how it came out of the House? Was it a unanimous vote, or what the vote count was? Or I don't recall what it was. Or maybe research could tell us if Natalie Nelson is on the line.
Natalie is on the line, but this is Jason Thompson again. I had it pulled up from before. It did pass unanimously, 123-0.
Thank you, unanimously. All right, thank you. That's good to know. And committee, if you'll remember, last when we visited this issue, we had an amendment brought to us regarding payment for the program, and we didn't work the amendment, but we talked about it, we discussed it. So if we could refer back to that amendment, and I'm not finding my copy of the amendment in my file, but I don't know if never mind, I misspoke, so I have it here, committee. It is on page 3 of the bill. It's a proposed amendment to the Senate bill, but it will be exactly the same amendment for the House bill, and regarding where the fees are attributable to and how the program gets paid for.
Madam Chair.
Yes, Mr. Thompson.
This is Jason Thompson again. I'm going to just share the balloon that I believe you all received on 2026. So there is a House version that you received. It looks like this on the front. And it looks like you would have received that on the day you heard the testimony on 2026. And there is the provision on page 3 that you were speaking of.
Right, yes. That's slightly different than what we were looking at on the Senate bill.
Correct, Madam Chair. Jason Thompson again. You'll recall that you had discussed one proposal on Senate Bill 3 after the parties conferred, I believe the courts and the community corrections representative. They conferred, came back to you with this proposal on 2026. So I wanted to make sure you had the right one.
And we're looking at House Bill 2026 as amended.
Madam Chair, at this point, it is just House Bill 2026 with this proposed amendment. It was not amended by the House.
Great, that was going to be my next question. So the House did not adopt this amendment. Is that correct?
Correct, Madam Chair. The House passed this bill with no amendments, and now you're being asked whether you want to amend this bill.
Thank you. Committee, then, the issue before us then would be we have two potential amendments for House Bill 2026. And Mr. Revisor, I want to make sure I have this right. Could we consider then the amendment we were looking at on Senate Bill 3 as well as what the House was looking at on House Bill 2026? Of course, working one at a time.
Thank you, Madam Chair. Jason Thompson again. Sure, I believe you could consider the one on Senate Bill 3 if you would like. I could pull that up if anybody wants to offer that and discuss that. But it would be comparable to, we could transfer it over to here. They should match up.
Committee, we have discussed previously the proposed amendment to Senate Bill 3. So if we want to work that amendment, I think the committee would be more familiar with that amendment than what the House had considered before them and decided not to adopt. So with that, if we can look at the proposed amendment to Senate Bill 3, and I would entertain any discussion on the proposed amendment. Mr. Thompson, are you able to pull that up on the screen?
Yes, Madam Chair, I could. I just wanted to correct one thing. The House never considered this amendment. This was the amendment that Stuart Little, the representative for the community corrections folks, asked the chairperson to allow it to be distributed to the Senate. So this is a new proposal from them, as was the Senate Bill 3 proposal you had before you at the previous time. But neither of these were considered by the House. They are drafted actually for you, the chairperson, by me.
Thank you. I appreciate the clarification. So the House had not considered any amendment to HB 2026. Is that correct?
Correct, Madam Chair. Jason Thompson again. There was some discussion by Mr. Little and the others, but no amendments were considered at that time. The amendments were discussed with your committee, and then I was asked to prepare one on Senate Bill 3 and then a different one when 2026 was considered. But the House never considered either of these balloon amendments.
Thank you. committee, are we clear on, yes, Senator Wilborn?
Thank you, Madam Chair. Either I forgot or didn't remember, but who proposed the proposed amendment to our Senate bill? What was the author of that?
That would be Stuart Little on behalf of Mr. Thompson. Can you remind us who he was bringing this on behalf of?
Thank you, Madam Chair. Let me pull up the official wording on that.
And I believe it was a compromise that the parties had worked out between the interested parties, because we'd asked them, please go work this out, and that's the proposal they brought to us. I have his testimony here from Mr. Little, and he was bringing this to us on behalf of the Kansas Community Corrections Association. And he was working then to bring this amendment to us. He was working with whether it was the Kansas Sentencing Commission or the I don't recall if Mr. Thompson, if you recall.
Thank you, Madam Chair. Jason Thompson again. Yes, I do. And since I drafted this on behalf of you, I'll take that as a desire for you to have me disclose that, since I did it on behalf of you at the time.
That'd be great. Thank you.
I worked with Mr. Little on behalf of the Community Corrections Association and with the judicial branch, some of the staff over there, Mr. Jurgensen, and some others from the judicial branch to work out this agreement.
Great, thank you. I didn't know which entity was also involved. I didn't recall. So we've got this proposed amendment for Senate Bill 3 coming to us as an agreement between the judicial branch and the Kansas Association of Community Corrections. So with that committee, do we have any discussion on the proposed amendment to Senate Bill 3? I'm sorry, Mr. Thompson, would you be able to pull that up on the screen?
Yes, Madam Chair. Just to be clear, are you planning to talk about 2026 or Senate Bill 3? I just want to pull up the right thing.
Sure, House Bill 2026.
Thank you.
Thank you.
You mentioned the compromise, and I was thinking 2026, but then you said Senate Bill 3, and I just wanted to make sure to not confuse everyone.
Absolutely. Sorry about that. We usually run things a little more smoothly, so apologize for the confusion today. Mr. Revisor Thompson, and is what we're looking at on the screen related to HB 2026 that was brought to the revisor as a compromise from the judicial branch and the Kansas Community Corrections Association, is that correct?
Yes, Madam Chair. Jason Thompson again. Yes, this is the balloon amendment on HB 2026 that was distributed to the committee, and I'll find the exact date here. It was on February 10th. You had a hearing, and we distributed this balloon on behalf that we worked on with Mr. Little and the judicial branch. And I can explain it at any time if you'd like.
Yes, if you could explain it. Thank you.
All right. Madam Chair and committee, you may recall from the discussion, although it's been a little while and we've dealt with a few things since then, the provision here is to, on line 14, make clear that the waiver of the supervision fee can be part of the memorandum of understanding that is entered into with a county or district attorney and the chief judge, or between the county or district attorney and community correctional services, right? So that provision needed to be clearer stated more clearly stated there. And then the amendments in here in the red strike in lines 21 through 28 is to remove the provision that would have sent all this money to the state treasurer, and instead make clear that all the monies collected by this section stay in the county general fund and will be used to fund the cost of diversion supervision there in the county, pursuant to the memorandum of understanding under the subsection. So if the memorandum of understanding is between the prosecutor and the chief judge, it would be used for supervision by the chief judge's court services folks. And if it were between the county or district attorney and the community correctional services under that memorandum of understanding, the money would go to supervision by community correctional services. So it kind of clarifies whichever MOU you're under is where the money goes, and the money stays locally in the county for that purpose.
Thank you. Committee questions for the reviser? Seeing none, then discussion on the proposed amendment. Senator Haley.
I didn't know if you were prepared to receive a motion on the amendment yet, or did you want discussion prior to?
Thank you. If there's no discussion on the motion, seeing none, yes, I would entertain a motion.
Thank you, Madam Chair. I appreciate the spirit of compromise that this amendment and those concerned have worked toward finding. So, having said that, would move that we amend the bill to include the language that's set forth.
Thank you. Is there a second? Senator Corson. Discussion on the motion. Yes, Senator Corson.
I would just say it wasn't that long ago, but it feels like a long time ago. But my recollection of when Mr. Little explained this amendment was really that all we're trying to do is make sure that the entity that is performing and doing the work, so to speak, of the supervision of the diversion is in fact the entity that is getting the funds. And so that seemed fair and straightforward to me. So that's why I'm supportive of adding this amendment. Thank you.
Thank you. Other discussion on the motion? Seeing none, then. You all have heard the motion. All those in favor on the amendment, aye. All those opposed, nay. The motion carries. We're back on the bill. Committee, further discussion on the bill? I don't recall, but we could look in the minutes probably on the Senate. Actually, we heard HB 2026 and whether we had any opponents. I don't recall that there were any opponents, but this seemed like a way to it seemed like a good program for those who would then have a chance to later put their life back together and get back into the workforce and things like that was some of the testimony we heard, as I recall. Any further discussion on the bill? Seeing none, then I would entertain a motion if we have one. Senator Wilborn.
Thank you, Madam Chair. I would like to move 2026 as amended out favorably.
Is there a second? Senator Baumgartner. Discussion on the motion, committee. Seeing none, then, would you like to move your motion?
I move my motion. Thank you.
Thank you. Committee, you have heard the motion to pass House Bill 2026 as amended out favorably. All those in favor, aye. Opposed, nay. The motion carries. We will now look to and turn to working Senate Bill 102, Senate Bill 102. If you recall, that was a bill we heard last week regarding earlier notice of anticipated release and an assessment regarding sexually violent predators. If Mr. Reviser could give us a bill brief, that'd be appreciated. Thank you.
Yes, thank you, Madam Chair. Jason Thompson again with the Revisor's Office. Senate Bill 102 is the bill requiring earlier notice of anticipated release from custody of a person who may be a sexually violent predator, and that notice goes to the Attorney General and a multidisciplinary team that's established by statute. And the main focus of the bill is creating an earlier process for this notification to occur, allowing, under current law, the written notice is given 90 days prior to release, and the bill would provide that from July 1 of 2022 to July 1 of 2023, the notice would be given 90 days to 2 years prior to release. So trying to get it out there a little bit earlier from release. And then after July 1 of 2023, the notice shall be given 2 years prior to anticipated release. So extending that time frame out to much earlier than their anticipated release date. The other amendment in the bill is dealing with the process that the court uses to determine whether probable cause exists to believe that a person is a sexually violent predator, not necessarily the process itself, but where the person is detained while they're awaiting the court proceeding to occur. The changes in the bill make clear that the court will direct that the person be taken into custody and detained in the county jail unless they're in the custody of the Secretary of Corrections. And then they stay there in that secure confinement until they're no longer subject to that confinement. And then they're transferred to the sheriff of the county where that petition is filed. So there's a little bit of clarity there about who's going to hold the person in confinement until that proceeding has completed and the court has determined that they are or are not a sexually violent predator and made that probable cause finding. And I'll stand for questions.
Thank you, Mr. Thompson. Committee questions for the revisor? Seeing none, then we will move to discussion on the bill. As you will recall, there was some discussion on the fiscal note. That there was a fiscal note of expenditures of 1.1 million in FY 2022. And so want to remind the committee of that. This was brought to us by the Attorney General's office, and we have some testimony in your folder from the Kansas Sheriff's Association as well, and want to open it up to discussion, hear what the will of the committee is and what thoughts are on the bill. Or if, yes, Senator Thompson.
So I remember this being fairly non-controversial, as I recall from the testimony. We're just trying to give people notice, and as such, I would make a motion that we report Senate Bill 102 out favorably for passage.
Is there a second? Senator Baumgartner. I think that recollection is pretty accurate, that it moves up the assessment while the defendant or the while they're still in prison, and to get the process started earlier so that there's less of a problem on the civil side, or keeping the case longer on the civil side, so we can get folks who are assessed and deemed to be sexually violent predators, get them into the program quicker to get that addressed. Was the intent of the bill. With that, discussion on the motion. Seeing none, do you want to close on your motion?
So I move my motion, Madam Chair.
Thank you. All, you've heard the motion. All those in favor, aye. Those opposed, nay. The motion carries. We will now turn to working Senate Bill 104. We heard that some time ago. We heard that on February 9th, so about 2 weeks ago. And if we could have a refresher on the bill brief from the reviser.
Thank you, Madam Chair. Jason Thompson with the reviser again. Senate Bill 104 is the bill requiring a court order to be issued directing a child to remain in a present or future placement for certain children in need of care when certain findings are made. So the amendment is to a section in our revised Kansas Code for the Care of Children. You'll often hear it called the CINC code, C-I-N-C. The current law provides that a court may enter an order directing a child to remain in a present or future placement if the court finds that the child is a child in need of care for certain reasons and that the child is not likely to be available within the jurisdiction of the court for future proceedings. And the bill changes that may to shall, so that a court is required to enter that order if the findings are made. So we go from a permissive order to a mandatory order, but keeping the same findings that are required under current law. I'll stand for questions.
Thank you, Mr. Thompson. Committee questions for the reviser? Yes, Senator Corson.
Thank you, Madam Chair. This was a recommendation from who did this bill? I thought came to us as a recommended piece of legislation. Can you remind me if that's true and from whom? Thank you.
Mr. Thompson.
Thank you, Madam Chair. Jason Thompson again. I'm looking to see who requested the bill in committee. Second. Because I have a recollection, but I don't want to say it if it's incorrect. I have it as listed as Senator Wilborn requested the bill on behalf of Senator Longbine. And then the testimony that was brought to you indicated that Mr. Brandmall with Geary County Secure Care was the person behind the idea and the main proponent.
Thank you, Mr. Thompson. Senator Wilborn.
Thank you, Madam Chairman. Just a little added history to this. About 4 years ago, the Senate and the Judiciary passed Senate Bill 367, which was the Juvenile Justice Reform Act. And like so many things on that act, there had to be some tweaks as we went along. A couple of years ago, we passed some legislation on a reporting requirement, and this is kind of an offshoot of that original 367. Removing the strikes from 3 to 1 and stuff.
The committee may recall that the testimony and the intent of the bill was to help with runaway children so that we could keep them in a secure placement and address that issue sooner rather than later. If I have that right, Senator Wilborn. Thank you. Committee discussion on the bill. Seeing none, is there a motion on the bill? Oh, Senator Haley.
Just wanted to underscore, Madam Chair, I remember the hesitancy for DCF to see the change, that because it took the permissiveness, and then I remember, was it Ms. Dorff or whomever, her screen was really sketchy. They were kind of concerned that we were.
Could you make sure you're talking to the microphone? Thank you.
Sorry. Thank you, Madam Chair. DCF doesn't often weigh in opposing measures we undertake. They're, of course, a state agency. And it does concern me that they did with this because of the discretion that would be taken from the court to make the decisions, to look at the overwhelming facts of the case. So that struck me as different, as odd, that they who implement the measures that come out of this committee and this legislature were not supportive, and it concerns me to the extent that I won't be supporting the bill. Thank you.
Thank you. Committee, other discussion? All right, seeing none. Is there a motion regarding the bill? Senator Wilborn.
Thank you, Madam Chair. I recommend the favorable passage of Senate Bill 104.
Thank you. Is there a second? Senator Bowers. Thank you. Discussion on the motion. Seeing none, then, would you like to move your motion?
I move the motion. Thank you, Madam Chairman.
Thank you. You've heard the motion. All those in favor, aye. All those opposed, nay. The motion carries. Would you like your vote recorded? Thank you. Committee, then we will turn to working Senate Bill 105. Senate Bill 105 concerns prohibiting denial of a petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. We heard that 2 weeks ago on February 10th. If we could have a reminder, bill brief from the revisor, please.
Thank you, Madam Chair. Jason Thompson with the Revisor's Office again. Senate Bill 105, brought to you by the Judicial Council and its Criminal Law Advisory Committee, does prohibit denial of a petition for expungement due to the petitioner's inability to pay outstanding costs, fees, fines, or restitution. We amend both the municipal expungement statute in Chapter 12 and the Criminal Code district court level expungement statute in Chapter 21, but we amend them in similar ways in the bill. There's a new section that provides the determination of when the person satisfied their sentence imposed and then is eligible for expungement after some amount of time has run from that date. That date is not determined, or how that date is determined excludes the payment of costs, fees, fines, and restitution. All of the timelines for how, for when you can request expungement are preserved, but when you satisfy your sentence would now exclude that payment factor. So you might be eligible for expungement earlier than you would be under current law. There's also a new provision that says explicitly a court shall not deny a petition for expungement due to inability to pay those outstanding costs and fees and such. And there's a provision that says a petitioner's unwillingness to pay rather than inability to pay may be considered by the court. Finally, there's a provision that allows the petitioner, or that requires the petitioner to remain responsible to pay all of those outstanding fees. They don't just go away. And for purposes of allowing collection of those fees, certain people would be granted access to the documents and records that are otherwise expunged so that they could go about collecting the outstanding costs or restitution or whatever the case may be. And I'll stand for questions.
Thank you. Committee questions for the revisor? Seeing none. Just wanted to hear from the committee as we move to discussion of the bill, what the will of the committee is. We had heard some testimony on this. Just wanted to know if what discussion there was on the bill, if any. Senator Thompson.
Yeah, I think that I'm trying to remember all of the testimony on this, but with regard to expungement, this is, and maybe Mr. Thompson can answer this, but you know, obviously we want people to be punished for their crimes, and part of that is restitution. I understand that some people, because of their inability to pay, they're not going to squeeze blood out of a turnip. But could you refresh my memory on, and maybe you covered it and I just missed it, you know, what other things are in place to make sure these people, you know, pay back to society what they've taken?
Thank you, Senator. It's a good question, and we'll ask the revisor to answer. This doesn't, my understanding is, and Mr. Thompson can clear this up if it's not accurate, that the sentence, the restitution, the fines, all that is not impacted by this. It's merely, you still have to pay those, but you can apply for the expungement without erasing those. And maybe Mr. Revisor can explain it better than I can, but I want to make sure I'm clear as well.
Thank you, Madam Chair. This is Jason Thompson with the Revisor's Office again. I guess I'll start from the nonpartisan, I have no policy position perspective here, that the bill doesn't propose to change anything about how restitution is ordered, how it remains due, how it's collected under current law. All of those procedures remain in place, and the bill specifically says the person is still responsible for restitution, outstanding costs, outstanding fines. So it would remain on their record, it would remain a court order, it would remain enforceable. So that is provided by the bill. And then I would just point to the Judicial Council testimony as the main proponent for the reason that their committee voted unanimously to support this finding. And they state that it's because those fines, fees, restitution, and such are part of your sentence. They are in the court's order. So if you don't pay them, you have not, quote unquote, satisfied your sentence that was imposed. The term in the expungement statute is satisfied the sentence imposed. That is the thing that starts the running of your time. So if you have to wait 1 year, it's 1 year after you satisfied the sentence imposed. So if you never pay those fees, you never get that year done and you never get expungement. And they are saying that is a burden on indigent defendants, and that eliminating that requirement would allow them to get it expunged, maybe get a job, maybe be able to pay those fees. So that is their reasoning for bringing it to you.
Thank you, Mr. Thompson. That's the recollection that I had from their testimony as well. Senator Pyle.
I'm just looking at the testimony from the Office of Judicial Administration, and they were neutral. And basically they say, for this reason, we request an amendment to clarify that the entirety of the expunged case may be accessible for collection purposes. So evidently they don't believe it's clear in the bill. Their contemplated amendment would strike the language that refers to, quote, any documents and information regarding the outstanding costs, fees, fines, or restitution, unquote. And then they want language that replaces that. It says, in the absence of this amendment, it may be necessary to halt referral of these debts for collection after expungement, leading to loss of revenue for state and local governments and stymieing efforts to collect on restitution owed to victims. I guess, Madam Chair, I'm just questioning, they brought their testimony. They requested an amendment to clear this up. It sounds like Jason, what he's saying is it's clear, but according to them, it's not. So just make sure everyone's aware of that. Thank you.
Thank you, Senator, and thank you for bringing that to the committee's attention. You do have in your testimony from the Office of Judicial Administration a balloon amendment. I think that's what you're referring to, Senator Pyle. Yes. On page 13 of the bill, first, and if yes, Mr. Thompson has put that up on the screen, that it would open up access to the file so that the restitution and the fines and the fees could be more easily collected by collection agencies, things like that. And Mr. Revisor, if you could explain the amendment.
Thank you, Madam Chair. This is Jason Thompson with the Revisor's Office again. As you can see, this is not a balloon amendment prepared by our office. But for the purposes that you need, it is sufficient. It was prepared by the proponent, or not the proponent, the Office of Judicial Administration, and included with their testimony. I was not asked to draft a more official version, so that's why we're here and using theirs. And I'm in a unique position on this bill because, as some of you know, Members of the legislature are on these judicial council committees and on the judicial council. So the legislative member of the judicial council committee asked me to attend a couple of the meetings where they were drafting this bill. And so I heard the discussion and helped craft this language before it was introduced. The discussion on this particular provision was trying to narrow the access after the expungement occurred to only those documents and information that were absolutely necessary for folks to see in order to make their collection occur. So as I stated, their position was they didn't want to stymie collection. They wanted that to be something that could still happen, and they attempted to do that with this provision. The Office of Judicial Administration believes that this is too narrow and that the way they allow access to the case file requires them to either, as I understand their testimony, requires them to either let you have access to the whole file or let you have access to none of the file. And so this language they believed was too limiting, and they would recommend access to the file so that they can perform the committee's intent. But the committee may not have been as happy with that, given that they wanted to narrow the focus. But it's sort of a policy choice versus a practical choice, and how the two need to be merged is the policy choice that's presented to you.
Thank you. Questions for the reviser? The discussion on the proposed amendment. Senator Pyle, did you have a question? No, sorry. Committee, what are your thoughts? Do we have any motion to entertain on the amendment? Senator Haley.
Thank you, Madam Chair. I'm not a member of the Judicial Council, and I do appreciate Mr. Thompson sharing the review with us, and Senator Pyle drawing their testimony regarding this. I certainly, wherever the bill goes, certainly I think it would be in our better interest to attempt to adopt the language in the proposed balloon as we have on the screen. It seems to certainly clarify what would be necessary by just saying the expunged case file instead of the litany of others. So I would hope or propose or move that we adopt the language as proposed by the balloon that we have.
Thank you, Senator. Is there Senator Thompson with the second? Thank you. Just to be clear, I, as a legislator, have not been on the Kansas Judicial Council. I believe I currently am as chair of Senate Judiciary, but I was not part of the process that originated the bill or the amendment. With that, committee, then, discussion on the motion. Seeing none, then, you all have heard the motion. All those in favor, and we're on the amendment. All those in favor, aye. All those opposed, nay. The motion carries. We're back on the bill. Committee, further discussion on the bill. It seems to be a good balance of requiring restitution and the sentence be carried out that was imposed. And though if we're looking at restitution and paying fines and fees, that if those are more likely to be paid if to get back to work, we can expunge those who are appropriate and prudent to have their record expunged, that they be able to go through that process, which was, I think, the intent of the bill. Any further discussion on the bill? Seeing none, then I would entertain a motion on the bill. Senator Haley. Thank you. Is there a second? Senator Thompson. Any discussion on the motion? Seeing none, then you all have heard the motion. All those in favor to pass favorably out Senate Bill 105 as amended. All those in favor, aye. All those opposed, nay. The motion carries. The second was Senator Thompson. Thank you. Committee, we are going to take up a speedy trial, the House version of that after turnaround. So please be prepared to take a look at that. And we will hear that briefly. We've heard a lot of testimony on speedy trial already, but to move that forward, we'll be hearing that after turnaround, and we'll then be working it. And with that, then for today, we are adjourned.